A very warm welcome to all. Today, I, Riya Khanna, a legal intern under Lexis and Company, am here to explain my topic, will or wasiyat under the Islamic law. This particular video that you are watching is part 2 of the topic. Before we move forward with the video, let us first revise what we understood in the previous video. So, in the previous video, I gave the meaning that will is the Anglo-Mohammedan term for the Arabic equivalent wasiyat, and a will or a testament or wasiyat has been defined as an instrument by which a person makes disposition of his property to take effect after his death. Further, the object of will is, according to the tradition of the Prophet Muhammad, to provide for the maintenance of members of family and relatives who cannot be properly provided for by the law of inheritance. Further, I explained the difference between hiba and wasiyat, where hiba is the gift which is included in the Muslim law, while wasiyat is made at the deathbed. Also, when a person who is on the deathbed gives a gift to someone, that is referred as mars ul maut, which means a gift during the deathbed. Further, Further, I explained the essentials of a valid will, where there are four essentials. First is testator, second is testatrix, third is subject, and fourth is the extent. So, about the testator is the person who makes the will. So, every major Muslim who is above the age of 18 years and of sound mind can make a will, and the age of the rules of majority is governed by the Indian Majority Act of 1875. Further, um, now let's move forward with today's video. So let's understand who is a legatee or a testatrix. So any person who is capable of holding property, Muslim, non-Muslim, insane, minor, a child in the mother's womb, etc., may be the legatee under a will. Thus, sex, age, creed, or religion is no bar to the taking of bequests. Legatee, including a child in the mother's womb, must be in existence at the time of making of the will. Thus, a bequest to a person unborn is void. A bequest may be validly made for the benefit of a juristic person or an institution, but it should not be an institution that promotes religion other than Muslim religion, that is Hindu temple, Christian church, etc. No one can be made the beneficial owner of the shares against his will. Therefore, the title to the subject of bequest can only be completed with the express or implied consent of the legatee, who has the right to disclaim. Further, the subject of will, so the property or the subject which is being included in the will, must be capable of transfer, and the property must be in existence. The testator must be the owner of the property. A Muslim does not possess an unlimited power of making disposition by will. There are twofold restrictions on the power of a Muslim to dispose his property by will, which are in respect of the person in whose favor the bequest is made, and as to the extent to which he can dispose of the property. This is obvious because the object behind the restriction is to protect the interest of the heirs. A bequest, so in the case of Husseini Begum versus Muhammad Mehdi, it was held that a bequest of entire property to one heir to the exclusion of other heirs is void. Where the heirs refuse to give their consent, the bequest would be valid only to the extent of one third of property, and the rest of the two thirds would go by intestate succession. No Muslim can make a bequest of more than one third of his net asset after payment of funeral charges and debts. In respect of bequest of one third to an heir, the consent of other heirs is required in Sunni law, but not in Shia law. In case of a non-heir, the consent of heir is not required in both. The above rule of bequeathable one-third will to apply to the case where the testator has no case. So the right to government to take the estate of an heirless person will not in any way restrict the right of a person to make a disposition of his property as he likes. Thus, government is no heir to an heirless person. Further, no consent is required for bequesting one-third property to a stranger. Consent of heir is required only in bequesting one-third property to one heir. Consent is required to bequest more than one-third property to anyone, and bequest of whole property is always void. No consent whatsoever if person is married under Special Marriage Act. So that is all for about will or wasiyat under the Islamic law. Thank you so much.